Hi, welcome to the program on how to pass down your vacation home. I'm Tim Borchers, founder of Borchers Trust Law and a practitioner in the area of vacation home planning for nearly 40 years. Without further ado, our program for tonight is going to take you through the process of the planning and some of the considerations and concerns. So it's a fact that those of us who have vacation homes and keep them for any length of time, I suppose there can be a love-hate relationship. But for the most part, we love our vacation homes. It's a happy place for us and our families. So the question is, how should we preserve that wonderful legacy for our families? I'm going to start with a short history of the American vacation home, just for the fun of it. And then let's talk about some real problems inherent in the heirloom or family vacation home succession, what works and what doesn't to make a success of your family legacy. I'm happy to say that I've been selected as the next author of the Saving the Family Cottage 7th edition, which will be coming out sometime in the next 12 months. I don't really have a date on that yet. But that is probably the leading book that people can pick up as families and lay people, if you will, to learn about some of the risks and opportunities associated with planning for your vacation home. We also have tools available on our website, and I'll display those for you at the end of the program tonight. So briefly, a history, you could think of perhaps the first cave dwellers thought, let's move down to the sea side for the warm weather. Maybe that was their vacation home. They lived in a tree there, and they lived in a cave back in the woods during the winter. But I would say, as a practical matter, probably vacation homes in America were the result of having some wealth to build a second home. And one example would be this Highfield Hall in Falmouth, a wealthy business owner from the Boston area building a place to run off to in Falmouth. People who had a good deal of money and could get there by train for the most part in the 1800s built the mansions like the Breakers and the home that the Kennedys called their compound was built in the early 1900s, even though they didn't acquire it as a family until 1928. But for the rest of us who weren't building mansions like that, hotels were really the way to have a vacation in a different location. Hotels were accessible by train for the most part, a few of them by ferry. You could have gone out to Martha's Vineyard, for example, to get to a nice hotel. But for the most part, it was going to be by train. And automobile, really, remember, wasn't an option back in the 1800s. So we're really talking about the place for the masses to be able to get away. And probably for a lengthy stay, you might be there for 2, 3, 4 weeks at a hotel like this one, the Menahunt, which unfortunately met its demise in 1918. Affordable resort communities were also springing up in the 1800s. Falmouth Heights, 1871, a community there. Ocean Park in Old Orchard Beach area in Maine started as a religious community with tents and then eventually some cottages. Martha's Vineyard Camp Meeting Association, also a prominent example that's still around today of small, mostly cottages on small lots, but very affordable and a nice place to run off to. What we saw with the development of properties in the early 1900s, late 1800s, with again the railways and eventually automobiles and extension of roadways, was land grabs and subdivisions of large tracts of land into small pieces that could be sold off and built on. We saw this, for example, in Falmouth, in New Silver Beach, where lots were going for as little as $500 and homes could be built for, rather the other way around, lots were selling for a couple of $100 and homes could be built for $500, incredibly. A great book that people enjoy reading just because if you've had a home in the family for a long time, it's a nostalgic run through what it's like to have a home for a couple of generations, very often just seasonal properties. Um, so this particular story, The Big House, was a bestseller and came out in 2003. And eventually the home, however, couldn't stay in the family any longer. It was sold to a member of the family who winterized it and made more use out of it. Then there were a lot of rustic camps like this one in upstate New York. Um, it was no more than a 4-room cabin. This was my grandparents' place. That's me and my siblings visiting there in 2008 after our ancestors had all passed away, and we paid a pilgrimage to the place. Unfortunately, it was left to get run down by our cousins, those nasty cousins. Uh, all right. Then I like to think of then there was just a post-war boom of just building, 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 lots of second homes. And that's partly just a function of the post-World War II prosperity. There were new, yet more communities that were growing up, no more camp meeting grounds, but places like um, the Lake Tahoe Lake Village Resort, or a place that my family has a home in Swissvale on Winnipesaukee in New Hampshire. The 60s and 70s was a boom time for that. Gentrification, so even deeper into the islands, like this place on Martha's Vineyard. Some of you might happen to know who owns this place, at least last I knew, unless they've sold it. This belongs to the Obamas. But gentrification, tearing down some of the more humble dwellings or buying up farmland, vineyards, etc. What this slide is intended to show is that the building boom, for example, again, this happened to be Falmouth statistics, but between 1970 and 1999, so roughly those 30 years, 55% of the housing stock in Falmouth was built. Most of that, 95%, was single family homes. And those are the homes that today are starting to get older. They're being rehabbed. Some of them are being torn down and replaced. I think it's also interesting what the pandemic did to vacation homes. Many of you are aware that people were working from home, and so they bought a home where they could work remotely. And so not surprising that some folks bought homes, and that drove up prices during that period of time. So let's get into the nuts and bolts here. So what is this about saving the vacation home anyway? I think saving the home is exactly what we need to do in many cases because we need to save it from ourselves. We're not good at sharing a home together, it turns out. So we need to plan this out. If the second home is truly part of your family's legacy, you've had it around for a while, people enjoy it, and everybody from the grandparents to the youngest grandchild wants to be there, wants to keep it in the family, that's an indication it's worth saving. Left unprotected, valuable properties like this are lost every day, every year. And these can be simple cabins in the woods, cottages, mansions, former beach colony homes, as we've seen, all the way down to RV parks where people park a trailer, a camper for the summer. The success stories really are the result of planning. If people think ahead to how this is going to pan out, providing some funding to whenever they can afford to keep the family in the home, and develop some kind of mission statement for how the home should be used. The best plans incorporate help and input from advisors and family. The failures are those stories where there isn't a plan, there isn't uh, a uh, a system set up ahead of time to encourage cooperation and to avoid the other uh, ultimate terrible result, which is that people end up suing each other to divide the property, known as a petition to partition. And that's, you might not think it's a lawsuit, but it really is. It's one member of the family who's now a co-owner with siblings or cousins that says, I've had enough. That might be out of exasperation or just the passage of time, but they bring an action in probate court to divide the property, force a sale, and divide the proceeds. Predictable difficulties in owning a home together. So charging family members for expense and use. Some people are adamantly against that. Others are more practical. Deciding what improvements should be undertaken and at what cost. You get rustic places that people want to keep rustic, and some people feel opposite, that we ought to add 3 or 4 bathrooms to the cabin in the woods. Should we be renting the property out to raise money or not? And I think if families really value keeping the property in the family, then they're going to have to resign themselves eventually to renting it out, unless there's a lot of wealth to support the property. Providing for a means of buying out siblings. We have cases where families insist that anybody who wants to leave doesn't get a penny. If you don't want to be part of it, then goodbye. Uh, and that seemed to be easier with properties that were very humble in their beginnings, might have been bought for under 100 grand, maybe far less than that. But now many of those properties are worth not hundreds of thousands, but millions. And so the idea that you're going to just leave a sibling of yours high and dry with no reward, financial reward, doesn't always set well with people. On the other hand, there are people that feel the primary value is to keep it in the family. And so if you don't want to be part of it, that's fine. And you don't want to contribute, the rest of us will, but you're now going to forfeit your interest in the property. Maybe we can provide some money to help the buyouts. Maybe we can equalize the estate by giving one person more money or life insurance proceeds and somebody else part of the property, or maybe all the property. Other difficulties dealing with individual owners, personal, family, financial, health issues. That threatens all the owners, because you run out of money. What's going to happen? The property is going to have to be taken, sold for the payment of your bills. Bankruptcy, divorce, these are all factors that can run the family compound into a sale or liquidation. Number 6 was limiting or not. Who can be the next owners? Who can you give the property to? I have found that it's not very popular to include spouses in that. Certainly not unmarried partners. Stepchildren, question mark, maybe. Second spouses, definitely not. And adopting a ownership agreement that all can agree upon. So the co-ownership terms will specify, how do you pay for things, what are the dues, what assessments, what if somebody can't pay, how is it governed, who can you pass it down to, et cetera. So all of those important terms should be thought about ahead of time. So sometimes what my clients don't want to hear, but I have to tell them, is that the real remedy is to say, sell the property. That doesn't necessarily mean you have to sell the moment mom or dad has passed away, but it could be that you're selling within a couple of years. And so parents say, look, unless you agree on all the terms to keep the property together, you shall sell the property within 12 months, 2 years, 5 years, but something that's relatively short in time. And if you're going to provide for a length of time, you ought to provide funding with that, so that while your children are hopefully enjoying it for the last hurrah, if you will, that there's money to pay for it, so they're not having to nickel and dime each other. Um, if you are going to have a sale, then you should be authorizing the children to be the buyers, usually at a reduced rate. At the very least, you would take off 5% for not having to pay a broker. You might take off 5% or more for accepting the property in as-is condition. And depending again on how much the family values the property, maybe even more. So I've had families that have had remote island properties on lakes that are hard to get to. And there's not much of a market for those properties, but they're valuable to the family. And if anybody wants to be bought out, there's a very deep discount for that, such that they might be getting 25 cents on the dollar or even less to be bought out. Or again, it's uh, so therefore it's easier for those who are buying the property to be able to afford it, or they might even get nothing at all. If you are going to say you get nothing to be bought out, it may be wise to have what we call a clawback provision, so that when the property does get sold for a profit, maybe a handsome profit, that there'll be some payment to those who got bought out early, either for nothing or for very little money. Um, my question would be for many families, well, if a sale is the way we're headed, because it doesn't look like we're going to be able to agree on things, what is the cost to your family? What's the cost to your family values if you lose this valuable property? If the property is sold and you have nothing to show for it at the end of the day, is that an acceptable price to pay? And when we face the prospect of having no home left, especially one that we've had around for a long time, many people find that to be unacceptable. And so therefore, we need to find a way, we are driven to find a way to keep the property in the family. So I'm going to finish most of this program by talking about the case of Martha, who has a lovely $2 million beach access home in Falmouth. She's 71. She was widowed and is now remarried. Dan is her new husband. More about him later. He's not really going to factor into this too much. Anyway, Martha is in good health, but there is a family history of Alzheimer's. And more facts are she has 4 children, and Dan happens to have 3. 2 of Martha's kids regularly visit the property. They love being there. They're very interested in keeping it. The 3rd child loves the home, but is not sure she can afford to be there. She happens to live further away as well. And the 4th child happens to have a disability and would not be able to use the home after Martha is gone, uh, probably because of their close relationship with Martha, or maybe even dependency on Martha. Martha's attitude is, I'll hopefully leave them enough money for them to keep the house if they want to. They'll figure it out. So that is probably the most common expression for people who are uninformed about the pitfalls of this area of inheritance, is figuring that their children are smart. They're mostly nice to each other. They'll figure it out. All right. So let's delve into a few more of these issues, especially for Martha's case. All right. So Martha's okay health right now, but what if poor health comes her way? That might be the Alzheimer's that's in the family, or it could be any other cause. Her second marriage certainly complicates the estate. So hopefully she did a prenuptial agreement. Everybody in a second marriage situation should do one. And that prenup would have said, among other things, that her second home was off limits. Protection of disabled child share is important because, of course, one characteristic of the disabled individual is that they need money for support. The government will pay, but they won't pay if they see that the disabled person has money of their own, including an interest in a home. We had a property owned by a family where the disabled individual lived in the state of Michigan. The property was also on Cape Cod. And the disabled individual had to disclose in her application for public benefits that she was a part owner of a home in Massachusetts. They denied her benefits until she could show that she had sold the home. So she tried to find siblings to buy her out. The siblings either couldn't afford it or didn't want to buy her out. And so the whole property had to be sold. It could not stay in the family. So that was not the happy ending we were looking for in that case. In another case, we had one sibling who was able to find a real estate agent willing to sell her 1/6 share of the property. And while that's theoretically possible, you could say, I own 1/6 with my 5 siblings. I'll sell that to somebody. Somebody might pay me for something for it. And there was a realtor willing to sell it. And supposedly there were people interested in looking at it. And that also ended up in a sale of the property because the other siblings wouldn't hear of it. I always wondered, well, you you might become a 1/6 owner, but how do you share that with other people who are total strangers? And what are you going to do? Bring your own furniture because you don't even own the contents of the place. You own a 1/6 interest in the property. So there's some interesting complications, to say the least. Other things that can be disruptors to the inheritance are Martha's estate would have to pay estate taxes. Does the property have to be sold in order to pay the taxes? How affordable is keeping this very nice home to the heirs? And of course, disputes over keeping the home, all the terms that we have to work through, the problems we're going to have to work through. And another hindrance to getting this ironed out is just Martha's own attitude of they'll figure it out. So we have to have a talking with Martha. So we're talking to Martha like, look, I know your kids are smart, and I know that they respect you, they love you, they get along right now. But some of the things you've mentioned, people that are not necessarily all in on this, and the disability question. Um, and you mentioned that maybe one of your children might be going through a divorce. Those things are disasters for trying to keep a home together. We have to do some planning. So let's start thinking through some scenarios. So one idea is let's plan for those who are interested. Remember this fact pattern, 2 out of 4 were likely to be able to or are interested in keeping the home. Allow those who are interested to stay in this property to do so if there are sufficient assets in the estate to equalize with those who are not going to stay in. So my fact pattern is that since Martha has 4 kids, it turns out she has a over $4 million estate. Now, after estate taxes and bills are paid for the estate, she has a net estate of about $4 million, which divides very conveniently into $1 million each, right? For each of the 4 kids. The home happens to be worth $2 million right now, or $500,000 each if you divided that 4 ways. So in other words, if one child said, I'm going to buy out the other 3, they'd have to come up with $1.5 million since they're already the owner of 1/4 of the $2 million home. So they come up with the other 3/4 or $1.5 million, which sounds like a lot of money for most people. Or if 2 of them said, we want to keep it, then those 2 have to come up with $1 million to buy out the other 2. Now, fortunately, there are other assets in the estate at the moment, although who knows what'll be there when Martha dies. Those other assets are also worth $2 million or about $500,000 each. So that's a very convenient fact pattern, isn't it? If the children who are doing the buying don't actually want to inherit any cash, they could say, we'll just use all of our cash, and the two of us that want to stay in, and we'll buy out the other two. The other two will get $1 million in cash. We'll get the property and no cash, but theoretically that could work. Problem is, we have a lot of things to control for. Between now and Martha's death, the value of the property continues to rise. Uh, in this town, for example, property values went up 16%, or maybe that was the whole state of Massachusetts went up 16% in the past since April of last year. Um, and the rise in prices always just seems to amaze us. And second home communities are not immune to this. Second home communities can also go down in value a lot faster. Uh, in New England, second homes we have the highest concentration actually in the country of second homes. The, the states in the country that have the most homes, it turns out, are Michigan and California. That's where most of the second homes are. But the highest concentration is right here in New England. All right, so two children want to buy the other two out at full price. If they do, they're going to use up all their money. Can they justify that buyout? What else could we do to help plan this? Well, one thing we could do is we could reduce the price. So Martha could say, I'm going to preset the price at today's value. I just finished a plan with a widow who has a much more humble cottage than this one in New Hampshire. And what we decided is that in her case, one child who lives a lot farther away, North Carolina, and two children that live in Connecticut, she anticipates that the one who lives farther away isn't going to want to stay in this, but she wants her to have the option to do that. What we decided was that she would lock in the price of the date of death value for her home in New Hampshire. Right now, that property is worth around $300,000. And her daughter, who's not rich, but she's okay off, would be missing out on $100,000 of inheritance if she just left the house to the other two siblings. So Martha wants her to have the option to be able to get something. And I won't explain the entire setup that we created, but essentially we said that daughter could stop paying her share of the upkeep of the house in exchange for not getting any appreciation in the value of the house until such time as it eventually gets sold by the other siblings. She forfeits the right to use the property and any income produced by the property. And if the property is ever sold, again, all she gets is the original 1/3 of the original date of death value, minus what she hasn't paid for all the intervening years to support the property. So if she was going to get 100 grand, she would get 100 grand minus, say, $5,000 a year for 20 years that she never contributed. That would use up the entire $100,000, $5,000 a year for 20 years. But she would not profit by the property appreciating in value when she didn't contribute to it. But if it was sold while there was still some equity for her to receive, she'd get a piece of it. Sometimes we have to get complicated with our formulas, but there are ways often to figure these things out. And in that particular case I'm thinking of, the client really went through several iterations of this planning until we finally hit on the one that she really liked. Buyers need to get a mortgage. So sometimes that's the way it goes. You want to own a second home and buy your siblings out, get a mortgage. So in this Martha's case, if two siblings want to buy the other siblings out at $500,000 each, maybe they can get a mortgage on their own home, their primary residence, for 500 grand and come up with the cash that way, or they could mortgage the property itself. One of the formulas that a lot of clients have been attracted to is one I've developed called 10 years and we're done. And this is a great chance for keeping the home affordable for a period of time setting aside out of the estate. So Martha could say, I'm going to set aside money out of my estate to help pay for the home for a period of years, let's say 10 years. And let's say that Martha's home cost $25,000 a year to maintain. So she'd need at least $250,000 to maintain that property. Maybe we could make some income off the 250 if we invested it. That's speculative, but depending on interest rates, maybe we can get some earnings. Um, and at the end of the 10 years, the family members can say, hey, we loved being co-owners together. This was great. We always got along. And now let's extend this and allow them to do like 5-year extensions. Now they're going to have to start paying for it on their own. So this is going to be a test. And at the end of every 5-year period, any of the remaining siblings can say, tell you what, we've had a great run of this, but I'm ready to move on. You know, I live in Alaska now, and I really don't want to come to Cape Cod. Um, then there's a take it or leave it approach, which works in a limited number of examples, where clients have just said, um, you know, I really want this to stay in the house. I'm surprised at how many people actually choose this option. Uh, and where it usually shows up is they say, as to the current generation or the next generation of inheritors, my children, as to my children, um, if they don't want to be involved in this, then that's fine. No hard feelings. Go your own way, but you're not going to be an owner. You're not going to be an owner. And if we sell the house someday, you're not going to get full value for having been an owner of this property or having inherited it. You know, either stay in this and pay your fair share, or that's going to be the end of it. It's kind of tough love at that point, because it's uh, you know, the one who can't afford it might be the one who enjoys it the most, or has family, their own children, that really enjoy it immensely, and it's a shame for them to not participate. You may remember that a few minutes ago I said you could also have a clawback provision, meaning that you claw back some of the profit that you lost out on by giving up your interest in the property. But that has to expire after a certain period of time. So what often accompanies this formulation is that somebody says, well, I'm going to give up my interest in the property. Have at it, the rest of you. But for the next 10 years, they would be able to recoup some of the profit if the remaining family members end up selling at a profit. So that usually goes something like they would get 90% of what they would have received in the first year, 80% the next year, 70% the next year, et cetera, until eventually they don't receive any of the share of the eventual profit. Setting aside money is a big help. So let's talk about that. Sometimes it helps for the parents, the planners, to find a particular source for the money that's going to support the second home. A really convenient place for that is the sale of the primary residence. So that'll give us a nice pool of funds. We could set up the plan for the vacation home that we'll keep this together as a family unit as long as the money lasts. So we might have a goal figure of $500,000, for example, to support the property. We may be able to get that out of the sale of the primary residence, or maybe from a life insurance policy. An IRA, a Roth IRA particularly, is an excellent way to do it. But whether you take the money off the top or take it from the proceeds of the sale of something else, when that money runs out, then the family simply has to sell, unless they choose to extend it and create an agreement that has the terms for extending. Now, a trust fund that they add money to every year works great. Hopefully, the family members can contribute to that if they really want the property to stay and continue to extend it. Let's talk about taxes for a moment. So it's always sensible to be mindful while you're alive. If you have a second home, you don't get the tax break that you have on a first home. So on a first home, you get to exempt $250,000 from capital gains for each owner of the home. So for most couples, that would be $500,000 total exemption from capital gains, uh, where you don't have to count that much and therefore save the tax on it. Capital gains can be higher than just 15%, which is the federal rate. It can include state uh, income tax as well. So here in Massachusetts, that would be uh, another 5%. So there's 20%. And if the property has been used as a rental, then there's going to be recapture of depreciation. So that's also at a higher tax rate, 25% usually there. Estate taxes, as we alluded to earlier. So you can't depend on a valuable home being passed down totally at its value if it's also subject to estate tax, either state or federal estate taxes, which we don't have time to go into in detail. Capital gains taxes have to be paid while selling during lifetime, but at death, under current law, the tax basis gets risen or raised up to the date of death value. This is known as a step up in the tax basis. This is a very important tax planning tool. That means that when the family sells after death of the parents, that they will only pay capital gains tax on the profit from the date of death until they sell the property, that the capital gain during that period of time. And then finally, tax deferred exchanges and charitable gifts. So tax deferred exchanges are useful where you've had a property in business use, so for use in a trade or business for at least 2 years, and you then decide to buy another property for use in trade or business. So you could buy another second home, you could buy another income producing property of any kind. Charitable gifts are also a cool possibility there. Nobody can afford to buy the property, but maybe there's a tax write-off for donating the property to charity and keeping their use of the property for a period, again, let's say 10 years. The family gets use of it, and at the end of the 10 years, the property goes to charity. Those all require a lot of planning, a lot of thought in order to implement. For Martha, the solution is in her hands. She should probably use a separate trust for this that we call an heirloom ownership trust or HOT trust. Or increasingly, I'm actually recommending that clients use limited liability companies for this purpose. Setting aside funds, so Martha has to get serious about putting money aside for this purpose out of her estate, preparing for those buyouts, creating the long-term agreement or framework. We really want her to lay down the law. Don't leave this up to her family members to figure out. Otherwise, we have to insist that the property be sold, and that can be written into her trust, her estate planning trust, or her will, in which she says, unless my children are unanimous in keeping it, the property shall be sold. And then if it's sold, allowing family members possibly to be the buyers. I'd love to talk more about the agreement itself, but we don't really have time to delve into what we should put in that agreement. But guess what? You can learn more about that through our website. So if you want to scan that code there, you can, or visit the website, borcherslaw.com/secondhomes, as you can see there. There, you will find access to some other resources, and that would include the heirloom property test. So it's just a simple test for you, for your family. If you score 6 or higher out of 10, is good indication that that you might be a good family candidates to try to keep the home in the family. If you're scoring lower than that, we might have a sale in your future. The second home planning checklist, a checklist to avoid future conflicts. Schedule a complimentary meeting. with me. So those are 15 or 30-minute pockets of time for me to go over your concerns and your interests. Some of the materials that we have to offer include a co-ownership agreement. This is one that we will provide free of charge. It allows current co-owners to set down in writing some of the things that they had not agreed upon in writing before. And that would include the carrying, how do you carry the costs, and what happens at the time of sale, and who can force a sale. Everybody should be able to force a sale so that you're not suing each other for partition. And I guess my final moral of the story tonight is, I think if your home is important to your legacy, then how are you going to be remembered? Homes have a lasting legacy. I'm not sure that inheriting a few bucks has nearly the same value and legacy that you really want to leave for your family. All right, so now what questions and answers might there be? And I'm going to look and see what's in the chat box here. Okay, question from the audience.
You said you were more and more recommending LLCs versus trusts. Is there a reason for that in Massachusetts in particular, or just, yeah, a reason why it's more attractive?
Yeah, part of my rationale there is higher values of properties over the last couple of decades since I started this planning. Liability concerns. So limited liability companies can save people from personal liability for slip and fall, a party that gets out of hand, that kind of thing that can happen on the property. Also, honestly, the LLC filing fee now seems more affordable at $500 a year in this state and closer to a national average of maybe $100 a year to keep your LLC current. You have to file with the Secretary of State's office every year. But it now seems more affordable. LLC agreements provide for a manager, or you can have all the members or owners be managers. So in general, we would have an agreement of members for the future ownership and control and passing down of the property. Sometimes we combine the two with a trust and the LLC. For example, when I have families that say, we want all of our grandkids to inherit the vacation home in equal parts. And in order to do that, you really need a trust to control the ownership until all of the children have died, so that then the grandchildren can all inherit in equal shares. So we would combine the two. But the LLC is probably my choice of preference at this point. Let me see if there's anything else. Anybody else in the room with a question? Yes, Mark.
When can we expect to see Saving the Family Cottage 7th edition?
Yeah, the 7th edition of Saving the Family Cottage. I'm supposed to be submitting my materials for that in the fall. So then I suppose they're going to be printing that next winter. So I'm hopeful that that'll hit the bookshelves by next spring. So I'm still learning what's going to be involved with that. Tara, can you refresh me on how to get back to the Zoom screen so I can see if there's any questions?
I'm looking at the chat. I don't see any questions right now.
Oh, thanks for checking. Okay.
Yeah.
All right. Well, if there's no questions in the chat, then I welcome everybody who is on Zoom to contact us, reach out. My personal email, tim@borcherslaw.com. And feel free to make an appointment also through the website. All right, if there's no other questions, I'll thank everybody for your participation tonight, and happy trails. Good night.